We are continuing on with selling real property and discussing title assurance. We're going to start with title covenants. So, first of all, broadly, title assurance is a method that the buyer uses to ensure that they're receiving property that's unencumbered by any cloud on the title. And what that means is that the title does not have any significant encumbrances. Remember, encumbrances are the rights or interests held by third parties that affect the value or use of the land. In the United States, there are three methods of title assurance that are widely used. The first is the title covenant, and that's where the grantor promises in the deed that the title is good. The second is a title opinion. A title opinion is an opinion written by an attorney or other professional, and it states that after searching the public records, it is their conclusion that the state of the title is, and then they put the state of the title. Title insurance is issued by a title insurance company. And the title insurance company issues a policy that insures the grantee's title. And we'll talk about the specifics of that a little bit later, but that's just a broad overview of title insurance. Now we are going to talk about title covenants. Now, before we do that though, I'd like to just remind you that when property is sold, what is being sold is the title, right? So the buyer is purchasing the estate and land, technically, and not the land itself. Okay, they're purchasing the estate and land, and that's why the estate and land, is also the title. Okay, so when we say estate of land or the title is the type of estate of land that it is. Title covenants. So title covenants are express promises that are made by the grantor about the state of title with respect to real property. Now, these promises are expressed in the deed transferring the title. They came about because of something called the doctrine of merger. So at common law, all the promises made in a purchase agreement expired at the end of the closing, right? Because at the end of closing, the buyer and the seller have completed all their obligations under the contract. And so once the grantee accepted the deed at the end of the closing, then all the prior promises were extinguished. And so grantees began requesting that the grantors put promises into the actual deed. So a covenant is a promise, all right? So they would put in the deed promises about the land, or sorry, not about the land, about the estate. So there are three types of deeds that are commonly used. The first is a general warranty deed. This is where the grantor warrants against all defects, whether they arose before or after they obtained the title. Okay, before or after they obtained the title. The second type is called the special warranty deed, and this is where the grantor warrants title against all defects, but only those after they obtained the title. Anything that occurred before, they're not warranting any defects against the title before they took title. Then there's the quit claim deed. This is where the grantor makes no warranties about the title. The grantee takes land. You can think of it as is. So quit claim deed is sort of an as is. Okay. Let's do some hypotheticals where we try to test your understanding of the different deed types. Let's say suppose A owns Greenacre and grants an easement to B so that B can cross through Greenacre. So easement is a promise that runs with the land. And so here A is giving a promise to B that they will be able to use the land to cross it through Greenacre. Okay. A then conveys the title to C, and C later conveys it to D. D now discovers that B has that easement. Okay. If D received a quitclaim deed from C, what are their rights? The answer is none, because a quitclaim deed contains no title covenants. Right? Quitclaim deed as is. What if D received a special warranty deed? D still would not have a claim. Because remember, a special warranty deed only protects against defects that occurred after the grantor received the title. And here the defects arose before C received the title. What if D received a general warranty deed? If D received a general warranty deed, then the existence of B's easement does breach the covenant against encumbrances. And D would have a claim against C. So we talked about the different types of deeds. So deeds have general warranty deeds and special warranty deeds both contain special title covenants. There's 6 standard covenants. 3 of them are present covenants and 3 of them are future covenants. We're going to talk about the present covenants first. Now, we're going to preface this. Present covenants are breached, if at all, at the moment the deed is delivered. At the moment the deed is delivered. That's when they're breached. That's when the clock starts tolling for the statute of limitations. All right, so the first standard covenant we're going to talk about is the covenant of cession. And this is a promise that the grantor owns the estate that they purport to convey. So if the grantor tries to convey a fee simple but only owes a life estate, they are breaching this covenant of cession. The next is the covenant of the right to convey. The covenant of the right to convey is a promise that the grantor has the right to convey the title. So if the grantor, for example, is only the trustee and not the owner of the property, then they lack authority to transfer the title of the property, and they would have violated the covenant of the right to convey. The third present covenant is the covenant against encumbrances. And this is the promise the grantor makes that there are no encumbrances on the title except for those that are expressly listed in the deed. So it could be breached if there is a prior mortgage, for example. All present covenants, including the covenant against encumbrances, are breached, if at all, like I said, at the time of closing. The grantor promises that he has good title at that moment, and the statute of limitation begins to run based on the date of the closing. General warranty deeds also usually contain what are called future covenants. Okay, so we said that present covenants are breached at the time the deed is delivered at closing, at the end of closing. Well, future covenants are breached after closing. And they commonly require that the grantee is actually or constructively evicted by a third party that holds superior title to them. So they need to actually have been evicted or constructively evicted. So what are the three future covenants? The first is a covenant of warranty. It is the promise that the grantor will defend the grantee against any superior claims of title. So if a third party comes along at a later date and tries to evict the grantee, the grantor must defend the grantee's title. The next covenant is the covenant of quiet enjoyment. The covenant of quiet enjoyment is a promise that the grantor makes to the grantee that the grantee's possession of the property will not be disturbed by anybody holding superior title. And if the covenant is breached, for example, this covenant is breached if the grantee is evicted because of the defect in the title. Finally, the covenant of future assurance. This is a promise that the grantor makes that they will take any future steps that are reasonably necessary to cure title defects that had existed at closing. The next case, Brown v. Lober, demonstrates the importance of paying attention to the statute of limitations when you're dealing with these covenants. So the question is whether the plaintiffs have shown constructive eviction, which is required to state a claim for the breach of the covenant of quiet enjoyment. The plaintiffs have to use the covenant of quiet enjoyment in this case because the 10-year statute of limitation had already run for the covenant of cession. So the analysis of the court centers then around whether or not there is constructive eviction, because remember we said that in order to argue that one of the three future covenants have been breached, you often need to show that there was actual or constructive eviction. So the court analyzes constructive eviction, and they say that because there was nobody that came with claiming superior title that evicted them from the land or prevented them from enjoyment of the land. Then the covenant of quiet enjoyment had not been breached. The court says, quote, until such time as one holding paramount title interfere with the plaintiff's right of possession, and in this case, we're dealing with mineral rights, so by beginning to mine the coal, there could be no constructive eviction and therefore no breach of quiet enjoyment. Now here's the thought question. Whenever you have a case like this, where where the covenant of cession, the present title, the covenant of cession, was breached, but the statutory period has run out and the plaintiffs cannot assert the breach of the covenant of cession, you want to also look to see if they may have an adverse possession claim. You have to satisfy all the elements of adverse possession, but there is a possibility there.